You're listening to a special edition of We Get Work, recorded live from Workplace Horizons 2025 in New York City, Jackson Lewis's annual labor and employment law conference. Over 500 representatives from 260 companies gathered together to share valuable insights and best practices on workplace law issues impacting their business today. Here's your personal invitation to get the insights from the conference delivered directly to you. We'll see you in 2026. Welcome to We Get Work and live from Workplace Horizons 2025. I'd like to welcome all three of you into our podcast studio this afternoon. Eric Magnus, principal in Jackson Lewis's Atlanta office, Connie Chen, principal in our Los Angeles office, and Noel Tripp, our principal in our Long Island office. So welcome all of you, and thank you for taking the time this afternoon. I'm going to start with Eric, only because you are on this side of the table. Why don't you tell us a little bit about yourself, where you're from, and your practice at Jackson Lewis?
Yes, thanks for having us, Alicia. My name's Eric Magnus. I'm a principal in our Atlanta office. I'm one of the co-chairs of our class action and complex litigation practice group. I probably spend 75% of my time litigating class and collective actions anywhere in the country other than where Noel and Connie live. No, I don't touch California, and I don't need to touch New York because we have people like Noel. But everywhere else, I can handle. I'll probably work there handling class actions, and the rest of my time doing wage and hour advice. As we'll discuss, it's still the case that most of our class actions are still wage and hour cases, although that is trending a little bit, and we'll talk about that.
So Connie, tell us a little bit about that California class actions practice.
Sure. So like you said, I'm a principal in the Los Angeles office. I've been practicing employment law in California since 2010. Split my practice between single plaintiff cases, the traditional discrimination, harassment, retaliation, wrongful termination cases, but certainly a substantial portion of my practice is class action and PAGA representative action cases. So the California Privates Attorney General Act has provided a lot of opportunities for employees and their counsel to bring claims. And so I try to keep the split about 50-50, but sometimes it definitely skews more towards the class and PAGA side. And I'm excited to be here to speak with you all today.
So we'll learn a little bit about what Chris Valentino talked about this morning, which is what is PAGA, right? So Noel, New York and you, what can you tell us?
Right. That's the 50th state. Since my colleagues have covered the 49, I have been resident in our Melville, Long Island office since I was a summer associate in 2005. So I was built in this lab for better and for worse. And I principally defend class and collective action wage cases predominantly under the New York labor law. As Eric referenced, there are lots of states where federal law is the focus and the sole focus. In California, they don't ever bother to even touch it. And we tend to do a little bit of both within the New York practice, but I'm predominantly focused on defending New York labor law claims on a representative basis.
So we know we're talking about class actions, and I think the title of your presentation talks about what you need to do to protect and defend our clients. Connie, can you tell us a little bit about what that presentation is and why it's important to talk about that at Workplace Horizons 2025?
Sure. So we are seeing in California and around the country just a surge in these types of cases, not just in the traditional wage and hour context, but also there are other types of class action threats that we'll talk about later on today regarding data privacy, AI. The law is constantly evolving, and new theories are regularly being propounded that expose our clients to risk. And so we'll be talking about, in addition to wage and hour and other class action threats, procedural developments that impact how we defend the cases and how we litigate the cases. And finally, preventative and defense strategies to minimize risk, both proactively and if a claim is filed.
So Eric, that's a pretty long list of issues that you're covering in your presentation. What are you hearing from employers? What are you hearing from your clients? How did you select those issues? What's rising to the top?
Yeah, so we pretty much decided on covering the topics that are trending. Even in the wage and hour space, like Connie said, there are constantly new theories developing. Like in this past year, we've seen certain types of claims, like exempt employees that aren't classified, that should be non-exempt during the time that they're training to do the exempt job. That's not a theory I had ever seen 2 years ago. Things like that. Most of the substantive wage and hour topics we're covering are going to be things that are new. A lot of cases that are in the wage and hour space surrounding remote work and the travel time and the impact of the travel time regulations on remote work. These are before folks were working, such a large part of the workforce was hybrid or working from home. Those were tangential issues, not things you saw mass class actions about now. That's a seriously trending area in the space. So, and Connie also mentioned there's certainly trending areas that are not wage and hour cases. Like there are class actions right now on both sides of the DEI divide, right? Like employees that are upset about decisions that are made pursuant to DEI policies and then cancellations of DEI policies. So we have to counsel clients on that and work through litigating the defense strategies on those kind of cases. So the way we decided, we're spending most of our time talking about sort of newer things, the trends that we're seeing in the class action space.
So Noel, Eric just described how many new trends are really kind of coming into this practice area. What are some of the biggest changes that you've seen from last year, and how are employers coping, and how can you help them keep up?
So I think, as Eric alluded to, you have a shift in the federal administration, right? Employers have for 10, 15 years now, and it's sort of at the intersection of wage and hour law and leave law, but they've been complaining about a patchwork of laws, right? They've been expanding their footprints and then bumping up against strangenesses in Maine or Idaho or Illinois when they have even if they have a California-centric view, they might still have a foot fault. And, the more the federal administration seeks to roll back floor regulation, setting of a floor, maintaining of a floor, the minimum wage hasn't moved since 2009, the more states, and you can, the heat map tracks the coasts, but not perfectly. You'll see them wade in, but they don't wade in collaboration, and so that becomes one of the hardest things to keep track of at the intersection of, right, during COVID, there were a million cutting edge issues, and then the return to work debate was, I think for most organizations, had wage and hour law lags because it looks at the work that's in the can. So now we have a few years of work that's in the can under these new paradigms. You let people move away, you let them structure their job remotely, or you had them travel, or whatever the case may be. And so now those have accrued and the plaintiff's bar has caught up to them, and that becomes part of the toolkit.
Is there ever any catching up to the plaintiff's bar? That's the question.
One other thing to add is, in this past year in particular, there's been one massive procedural development, which obviously we've spent a lot of time on this podcast about, which was Chevron, right? And that affects the class action space pretty significantly. So because when it's questionable, a lot of our clients question whether anything under federal law is quote unquote the law unless it's in the statutes, and that's an entirely new phenomenon over the last year. We don't advise it, and we talked about this in our presentation. But if clients could question any regulation and say that it's just the administration of the DOL's opinion, and it's not entitled to deference, and you can do a lot of headway with that kind of argument. Like there's no actual alleged unlawful practice because the practice isn't even unlawful unless you believe DOL. So that kind of phenomenon, the procedural issues have entirely come up since last year.
And tacking on to that, there are also constantly evolving issues regarding the enforceability of arbitration agreements and class action waivers, which continue to be met with a lot of hostility, certainly in California and elsewhere in the country. PAGA standing issues under the Private Attorneys General Act. There's been a split in the appellate courts in California about so-called headless PAGA claims. So we're closely monitoring that. And I think our job for our clients is to stay ahead of these issues, to anticipate what the plaintiff's bar is going to do, to spot what's coming down the road, and to provide practical guidance on how to respond or how to proactively avoid having to face these issues in a claim or a lawsuit. And we certainly have a ton of resources, California specific and otherwise. We have a California Class and PAGA resource group where we are constantly sharing knowledge, sharing developments, by the day, by the week. When the PAGA amendments were passed in June of last year, we formed a roundtable where we gather weekly to share experiences and discuss how the amendments are playing out on a practical level. And it's still a work in progress.
So, for the folks that are here at the conference and will be listening to you, and for the folks that are going to be listening after the conference on this podcast, what would you share or what would you say are some key takeaways people should know about the state of class and collective actions in 2025? Eric?
Yeah, so what I guess the main thing I would say is and this is kind of counter to everything else we've been saying, is nothing has changed, that you're hearing in a lot of other sessions, like the floor is ripped out under, whether it's affirmative action or anything like that. With our practice, it just things keep on keeping on. Like, yes, the theories change. Yes, there are different kinds of cases that are being brought, but the steadiness of our classic collective action practice doesn't seem to change that much. If I'm a client, I would take notes on sort of the substantive things that we're talking about and go back and figure out whether you have anything to worry about that, because prevention is always the best way to avoid getting sued on these kind of cases anyway, and prevention at the state level, right? As Connie and Noel have to deal with this way more than I do, but some of these state law theories are really cockamamie sort of things that you couldn't just sit down and rationally think of trying to audit my pay practices that this is something I'm going to think of. You've got to know from people like Connie and Noel, what's a spot to go look for. And that's what I would do if I was taking something home from this to try and keep yourself out of trouble.
And what about California? What's a good key takeaway for folks facing these issues in California?
Yeah, so class and PAGA risk is going to continue to be a big issue. And like Eric said, compliance is key, especially in response to the language of the most recent PAGA amendments that are the subject of another panel here today. It's about making sure your policies and your practices are in compliance, doing regular audits, making sure those audits are privileged to the extent possible, but also making sure that you're able to use them as evidence if that opportunity presents itself. And I always say an ounce of prevention is worth a pound of cure, and even more so in California and in this climate overall.
Noel, New York, and even perhaps how you work with your colleagues across the rest of the country to make sure, not just in Eric's area and Connie's area and your area, how we're helping our clients.
Yeah, to Eric's point, we are old hands, and some of these are eternal questions. Having a dispute resolution program in arbitration, a compliant multi-state class waiver program, probably within arbitration, but maybe without, is great. PAGA can take it away on a day. The mass arbitration risk is there. It's never a substitute for that substantive compliance. And some of those are just the multi-state diligence of I-dotting. The harder ones that are eternal to me is that, unlike other areas, nobody's business is or ought to be premised on discriminating against anyone or harassing anyone. But everyone's business is premised on there's a labor budget somewhere that's bumped up against these Byzantine rules. And now with Chevron, even what we thought we knew about them, right, is maybe ripped up. I agree. That's more of a litigation notion and sort of fun fodder for us in the cases that exist than saying, oh yeah, let's take a hyper aggressive position and throw DOL out into sort of the mania of early 2025 and the end of right, there'll be no NLRB and there'll be none of it. But that's still the focus, and then finding the tensions that you have to live with. Because to me, one of the most fascinating things is that the answer to the same question across Jackson Lewis clientele and across the different thoughtful clients is so different. The timing of change, the ability to change, the implementation of that change is going to vary by sector and geography. And even within an organization, especially one that's grown by acquisition, as so many of these have, they're like, we don't know what we bought, or we just looked at what we bought. We're doing it over an ABC company this way. You guys blessed it. It looks great. What are we supposed to do with this? Did you do due diligence? Kinda, but then we just sort of bought it.
The law is rarely black and white and often gray, as you've all sort of just described. Noel, Connie, Eric, thank you so much for joining us this afternoon in the studio. And we wish you luck with the rest of the conference. And we'll see you in 2026.
Our pleasure. Thank you.
Awesome. Thank you for having us.
Thank you for listening to Jackson Lewis's podcast, We Get Work. Focused solely on workplace issues, it is our job to help employers develop proactive strategies, strong policies, and business-oriented solutions to cultivate a workforce that is engaged and stable. Please tune into our next program, where we will continue to tell you not only what's legal, but what is effective. We Get Work is available to stream and subscribe on your streaming platform of choice, including Apple Podcasts, Spotify, and YouTube. For more information on today's topic, our presenters, and other Jackson Lewis resources, visit jacksonlewis.com. As a reminder, this material is provided for informational purposes only. It is not intended to constitute legal advice, nor does it create a client-lawyer relationship between Jackson Lewis and any recipient.